The Court of Appeal in Abuja has struck out the motion for an accelerated hearing for the case of the leader of the proscribed Indigenous people of Biafra, Nnamdi Kanu. Presiding over the case, Justice Jumai Hanetu-Saki and two other judges stated that the motion of accelerated hearing has been overtaken by events. The leader of the proscribed Indigenous people of Biafra, Nnamdi Kanu, is currently facing a trial in the Federal High Court as 8 out of 15 count charges bordering on treasonable felony preferred against him by the federal government were struck out. Kanu, through his lead counsel Mike Ozekome and his team, had approached the appellant court in an appeal marked number CA ABJ CR 625-2022 to challenge the remaining 7 counts against him. Ozekome had described the remaining charges against the IPOB leader as defective and baseless. While expressing concern over Kanu's state of health, his lawyers therefore applied to the court that their client is discharged and acquitted.
You must state with particulars the place where he allegedly committed the offense, the time, the venue. But in this case, all the remaining 7 counts, they are saying, 6 of them, that Nnamdi Kanu made certain broadcasts. Broadcasts from where? From the spirit world? You did not tell us. From Ghostland? You did not tell us. And you know what they did? That was because in an earlier objection to the first charge, where they said he made the broadcast from the United Kingdom, they tried to run away from that by now saying he made the broadcast without stating where he made the broadcast from. And the law is that you cannot charge a person in such a vague and evasive manner. The Federal High Court does not have global jurisdiction over crimes allegedly committed in other parts of Nigeria. The only count that they mentioned a venue was one of the counts where he was accused of importing a transmitter, and that it was accosted at Obolo Isuzo in Ihiala local government area of Anambra State. Of course, Ihiala local government area of Anambra State is not within the jurisdiction of the Federal High Court, such as to preside over the matter against Nnamdi Kanu in that respect.
Ikenga Ugochinyere, lawyer and spokesperson of CUPP,
is not
while
supposed to
stating the
address those
genesis of the
grievances.
agitation by the IPOB members alleged the government for participating in ethnic and political agenda.
Our people don't have a right to complain. Are you saying that the government that we pay tax to is not supposed to address those grievances? So because people keep on looking at this last end of this struggle, but nobody's looking at Buhari's wickedness, insensitivity, and ethnic agenda that led to this agitation. And like we said before, that this trial is baseless. What the president can do is to invoke the powers that is assigned to the Attorney General under the Constitution and discontinue this jamboree.
The lawyer representing the government, David Kasue, in his argument tells the court to dismiss the appeal brought before the court for lack of merit. The judge in his ruling therefore said the decision of the court will be communicated after a thorough investigation into the matter.
Adego, come on for road now.